attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the third in a multi-part securities law cast on the direct public offering process, commonly called a DPO, and the filing of an S-1 registration statement. Today, I'm going to talk further on the communications that are allowed during the DPO process. There are three primary regulated periods during the DPO process. The first is the pre-filing period. This period begins when the issuer decides to embark on a DPO. During this period, counsel will prepare the registration statement and audits will be completed. During the pre-filing period, a company must be aware of not violating gun jumping restrictions. Gun jumping is the dissemination of information regarding the issuer before a complete prospectus has been filed with the SEC. Communications prior, during, and immediately following the filing of a registration statement are strictly regulated to prevent an issuer from hyping the market in association with their offering. In addition, the SEC wants to be sure that investors' decisions to invest in an offering are based on information in a registration statement that has been reviewed by the SEC and that meets the disclosure requirements under securities laws. A gun jumping violation is considered the illegal offer to sell securities and accordingly is a Section 5 violation, which is very serious. The SEC considers all communications with the public as potential gun jumping violations. A very famous example was in association with the IPO of Google. In a pre-IPO interview, the founders, Sergey Brin and Larry Page, published an interview with Playboy magazine, and the interview made favorable comments about Google, of course. The interview did not include mention of the IPO or of the offering, and the comments appeared to be innocuous, such as, people use Google because they trust us. The SEC determined that the interview resulted in gun jumping and required Google to revise its prospectus to include a risk factor warning that the Playboy interview may have violated Section 5. In addition, the SEC required that Google publish the entire text of the Playboy article in its prospectus, thereby subjecting the text to the strict liability provisions for any information included in a registration statement. And also, the SEC required Google to address certain discrepancies between statistical information in the Playboy interview and that published by Google, even though those statistics were generated by Playboy and not Google. In Google and several other cases, the SEC has found that gun jumping is any information that is not contained in the prospectus and which could stimulate investors' interests. In addition to requiring revisions to a prospectus like they did with Google, the SEC can require rescission of securities that have already been sold. They can require that a registration statement be pulled and a cooling off period completed prior to restarting the IPO process, or they can even impose monetary and other penalties. There are exceptions and safe harbors to the gun jumping rules, but of course an issuer needs to be very cautious in navigating these waters. The second time period is the waiting or quiet period, which is the time from the filing of the registration statement until it is declared effective. During this time, the issuer can engage in limited marketing, offers only but not sales, and using only the filed registration statement. The last time period is the post-effective period, in which time period is from the time the registration statement is declared effective until sales are completed of the securities that are being offered. During this time period, the company's communications are also limited to the contents of the prospectus, of the updated filings with the SEC, now that it's a reporting entity, and of communications in the ordinary course of business. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about the information we've just covered, please visit securitieslawblog.com or contact me directly. Inquiries of a technical nature are always encouraged.